Now I'm going to discuss with you a very important topic, which is tort liability of public authority. Dear students, before we begin with this very topic, it is of supreme importance to understand the question as to what is tort. My dear students, tort is a civil wrong for which the remedy is a common law action for unliquidated damages, and which is not exclusively the breach of a contract or the breach of a trust or other merely equitable obligations. यहां पर आप देख रहे होंगे कि कुछ बोल्ड और अंडरलाइंड वर्ड्स हैं. आइए इनके मीनिंग्स को देखते हैं. सिविल रॉन्ग का मीनिंग है अ वायलेशन ऑफ नॉन क्रिमिनल लॉ. रेमेडी का मीनिंग है द मीन्स ऑफ रिड्रेसिंग अ रॉन्ग. कॉमन लॉ एक्शन का मीनिंग है अ सिविल जुडिशियल प्रोसीडिंग एट कॉमन लॉ. एंड माय डियर स्टूडेंट, बड़ा इंपॉर्टेंट यहां पर टेक्निकल वर्ड्स हैं जो हैं अनलिक्विडेटेड डैमेजेस, और इनका मीनिंग बनता है डैमेजेस दैट कैन नॉट बी डिटरमिन्ड by a fixed formula and must be established by a judge or jury. और लास्ट में इस स्लाइड में जो लफ्ज है उसको कहते हैं एक्सक्लूसिवली, और इसका मीनिंग बनता है एंटायरली. नेक्स्ट जो इंपॉर्टेंट वर्ड है ब्रीच. ब्रीच मीन वायलेशन. कॉन्ट्रैक्ट का मीनिंग है एन एग्रीमेंट इनफोर्सेबल बाय लॉ. और ट्रस्ट जो होता है ये एक राइट है enforceable solely in equity to the beneficial enjoyment of property to which another person holds the legal title. इसके अलावा जो नेक्स्ट टेक्निकल वर्ड्स हैं वो है equitable obligation. It means just or existing under the principles of equity. Dear students, thus tort is a violation of non-criminal law for which the means of redressing the wrong is a civil judicial proceedings at common law for damages that cannot be determined by a fixed formula and must be established by a judge or jury, and which is not entirely the breach of contract or the violation of trust or other obligations existing under the principles of equity. Now, ladies and gentlemen, we are going to discuss a question as to what is meant by public authority. Dear students, it is an authority or governmental agency that administers a public enterprise. Many examples can be found of the application of the law of negligence to public authorities engaged in providing services such as public transport, gas, health and electricity, water and sewerage, all of which are classed as proprietary functions. Now, my dear students, it is established कि अगर पब्लिक अथॉरिटी जो है वो मैसेज को सर्विसेज दे रही है तो उसके ऊपर जो है ये जिम्मेदारी है कि वो नेग्लिजेंट ना हो. अगर वो नेग्लिजेंट होगी तो लॉ ऑफ टॉर्ट्स के तहत वो जिम्मेदार ठहराएगी. तो यहाँ पर बड़ा इंपॉर्टेंट नेक्सस डेवलप होता है कि एक क्वेश्चन को डिस्कस किया जाए कि जनाब व्हाट इज नेग्लिजेंस. माय डियर स्टूडेंट्स, the term negligence is a noun meaning failure to give somebody or something care or attention. Care means be concerned or be bothered. Dear students, now I am going to discuss with you the but for test. Dear students, to gauge the cause of damage, the test but for test is applied. The respondent can prove that it was not his fault and the damage would have happened to the aggrieved anyway. I'm going to share with you an example. Dear students, a patient suffering arsenic poisoning was brought to a casualty doctor of a government hospital who did not give him treatment, rather sent him to his own doctor. The patient died. it was alleged that the patient died due to the negligence of the casualty doctor of a government hospital, it was held that the death was not caused by the doctor's negligence. He had to die anyway. Now I'm going to discuss with you another example, which is a direct relationship between cause and damage must exist to hold a public authority negligent. यहां पर मैं आपके साथ एक एग्जांपल शेयर करने जा रहा हूं. My dear students, a premature baby after birth suffered blindness. It was alleged that the government doctor was responsible for the blindness as he gave the baby high doses of oxygen. The respondent provided the court 6 probable causes for the blindness of the baby. It was held that it's very difficult to determine as to what caused blindness to the baby. Therefore, the doctor employed by the public authority could not be held negligent. Dear students, now I am going to share with you another example. उसका title है Public authority is not held negligent where it is proved that the injury was caused due to the fault of the employee. Dear students, the claimant, a handicapped of leg, while working as an employee, did not ask for a flight of stairs. Consequently, he fell down and got injured. He brought an action of negligence against the employer, meaning thereby against the public authority. It was held that his failing to ask for the assistance was a sufficient evidence as to prove that he was himself responsible for the injury. Now I am going to share with you another example which states that in a road accident, a police officer colliding with the defendant vehicle was killed. The respondent argued successfully that the accident was caused as the other police inspector was negligently handling traffic control. The defendant was held not negligent as there was no causation between the death and the defendant's act. My dear students, it is very clear in law of torts कि अगर पब्लिक अथॉरिटी नेग्लिजेंट है तो लॉ ऑफ टॉर्ट्स में वो जिम्मेदार होगी. नेग्लिजेंस जो है वो 3 चीजों का मजमुआ है. एक ड्यूटी ऑफ केयर है, दूसरा ब्रीच ऑफ सच ड्यूटी है और तीसरा जो है वो डैमेज है. कि अगर पब्लिक अथॉरिटी की ये जिम्मेदारी थी कि वो ड्यूटी को अदा करती और अगर उसने वो ड्यूटी अदा नहीं की और उसकी वजह से डैमेज हुआ है तो पब्लिक अथॉरिटी नेग्लिजेंट डिक्लेयर कर दी जाएगी.